In Amsalem, if I can turn the court to that also important decision, it's at tab 19 of our condensed book. It's tab 19, paragraph 50. The statement really resounds in the context of Lakeside Colony. In my view, the state is in no position to be, nor should it become, the arbiter of religious dogma. Accordingly, courts should avoid judicially interpreting and thus determining, either explicitly or implicitly, the content of a subjective understanding of religious requirement, obligation, precept, commandment, custom, or ritual. So it was when they had legal documents with intention to form legal relationships, the court was on solid foundation. They could apply neutral principles of law. But when they started getting into the custom and tradition, the religious beliefs and practices of the Lakeside Colony, then it became a vexing question.
Can I ask you if we're in danger here? I appreciate that you want to give us context and an understanding of what the religious background is and the cases that say when a court can exercise jurisdiction. Are we in danger of mixing up the concepts of jurisdiction and justiciability? Because when I look at the application for judicial review, it is strictly about principles of natural justice and the duty to be fair. There's no mention of religion. There's no mention of doctrine. So the first question, it seems to me, is there jurisdiction, which you started to address? The next question, if we're not satisfied on the question of jurisdiction, is the question of justiciability, which goes to the nature of the claim again, and that's where religious doctrine comes in. I thought Mr. Wall's argument was there's a property interest here, and therefore, assuming there's jurisdiction, he brings himself within the lakeside contractual property rights ambit of justiciability. Am I missing something? It just seems that we're blurring all the concepts by focusing on religious doctrine, and I don't see a word about religion except the reference to the Watchtower guidelines at the very end, but it all goes to procedural fairness arguments.
So Justice Abella, in response, the property or civil remedy or interest right that was pled by Mr. Wall was his loss of customers. There was not a property right. He pleads only that because of the decision by the congregation to disfellowship him, that he lost business from his fellow members of the congregation. It's our submission that there is no right to customers. That is not a civil right that would open the door to the review which is proposed in Lakeside Colony. So on the question of jurisdiction, that's where we say the door is closed. But then, as you point out, there is a further question, and it's a very interesting one that raises the issue of justiciability. If we're just talking about natural justice, does that raise a religious issue? Basically, from the court's perspective, why can't we just look at your process, your rules, and assess them just from the standpoint of natural justice? But the answer to that is that the congregation doesn't have rules. The congregation has religious beliefs and practices.